Brett in doing that. Brett is a law school graduate of Georgia State University. He graduated with honors and then graduated with highest pro bono hours. I'm not exactly sure what that means, but it sounds great. And again, appreciate it and looking forward to this panel. Thanks, Brett.
Thank you, Brian. Yeah, so first, thank you, Brian and Joe, for hosting this incredible conference and for asking us to put on this presentation. We're excited to be here to do it. Thanks to the ABA for hosting this great conference year after year, Carol, Rose, and Regina Ashman. And then, of course, thank you all for being here, fighting traffic to get here and to be here with us for this presentation. I think you'll enjoy it. We've done our best to make it very exciting. As you can tell from the background, we've chosen for the PowerPoint presentation. So you've got a defense-centric panel up here, all career defense lawyers, I think representing over 6 decades of experience on the defense side. These are folks who have been in the trenches on defense issues. And so first, I'll start immediately to my right. Is Tiffany Bracewell, and Tiffany is a Big Law rock star at Trout and Pepper. They're fellow GSU alums. Her record speaks for itself, and you'll hear that more today, especially the extremely impressive Devonia Inman habeas case. And I look forward to working with you, Tiffany, in years to come. Tiffany helps clients with civil and criminal investigations by the Department of Justice, regulatory investigations and enforcement actions by federal and state agencies, and high-risk civil litigation stemming from allegations of fraud. She has a breadth of experience in white-collar defense. She's the first ever fellow at the Federal Defender Program for the Northern District of Georgia in the 11th Circuit Court of Appeals. And in her pro bono work, Tiffany has assisted with the filing of clemency and habeas petitions, including for 6 years leading the firm's representation of Devonia Inman, who was serving a life sentence for a 1998 murder in South Georgia he did not commit. It has been the subject of esteemed podcasts and other media coverage. In December 2020, Mr. Inman was exonerated. I'll talk more about that on this panel. To Tiffany's right, everybody knows Nicole Kaplan. I got to know Nicole through my training programs for the CJA panel here in the Northern District, and other trainings that have been offered through the Federal Defender Program to defense lawyers like me. She's been an incredible resource. Her vast knowledge it speaks for itself. I go to Nicole whenever I have a question, and she always has the pulse on hot topics. She's a staff attorney with the Federal Defender Program, provides indigent defense for individuals charged with crimes in federal court in the Northern District of Georgia. As I said, she's a frequent presenter at CLE programs. She's a former law clerk to the Honorable Stanley F. Birch for the United States Court of Appeals for the 11th Circuit, and the Honorable C. Christopher Hagee, Magistrate Judge for the Northern District of Georgia. To her right, Ms. Emily Strongwater. Emily and I are preparing for a trial in October in a pill mill case, and we're excited to go to the healthcare program on, is it Friday? And learn how we can apply the Supreme Court's ruling in Ruan to get our acquittal for our client. Emily has been practicing law primarily in court for nearly a decade. Before private practice, Emily interned for Judge Totenberg. She was admitted to the panel, the CJA panel, in 2017, and since then the majority of her work is in appointed cases. She was a volunteer for former President Obama's administration's Clemency Project. She volunteers for the Center for Human Rights and Constitutional Law. She's had success with both federal clemency and compassionate release petitions. She sits on the board of the Tender Foundation, which provides gap assistance to single mothers in the Atlanta area. And last but certainly not least, Molly Palmer is a great follow on Instagram and TikTok, at Molly Palmer or at Atlanta Lawyer on TikTok. I reached out to Molly through social media randomly enjoyed her feed, and we got to talking. She told me I was spending too much time with former prosecutors, and we've become fast friends. We're working on a big case together in the Northern District of Georgia as well. So Molly's boutique criminal law firm in Atlanta is Palmer Law. She's an honors graduate of Georgia Tech, former special education teacher, graduated with honors from Emory Law, where she was named a Woodruff Scholar, former assistant public defender in DeKalb County, joined the Federal Defender Program in the Northern District of Georgia as a trial attorney in 2015. She's done every kind of defense case you can imagine, wrote appeals and presented oral argument before the 11th Circuit. She's graduated of Bill Daniels Trial Academy, National College of Criminal Defense, and the White Collar Crime College adjunct professor at Emory, where she teaches advanced criminal trial advocacy. She serves on the board of directors for the Georgia Innocence Project and on the alumni board for Emory. She's a frequent contributor on Court TV, Fox, ABC, NBC, and other national television media outlets. All four are some of my first calls when I need guidance on something. I look forward to continuing to shadow their trials, and I think you're going to enjoy hearing from them today. So that's enough talking really from me. I want to set the stage briefly. Today we're talking about post-conviction relief. So our client's convicted, no Rule 29, removed from mistrial and loss, but they're still innocent, of course. So the question is, what tools do we have at our disposal to overturn convictions, modify sentences, and obtain early release for your client? And when we sat down and discussed together how best to approach this topic, it was over boiled peanuts at a New Orleans Vietnamese fusion restaurant, and it became obvious how we were going to do it. There's some materials in your packet, no need to follow along. These are some of the topics we're going to cover, but without further ado, Molly, could you please set the table for us? We decided there'd be no better way to set the table for a hypo than to use the Joe Maldonado Passage, Joe Exotic case that is, it's got all sorts of procedural issues. And so I pulled, for purposes of this, just the DOJ press release. And Molly, you can start by telling us that that's all wrong.
It is, in fact. Thank you, Brett. I will say, I think at the outset, it is important for me to echo what Brett has said about Nicole and the Federal Defender Program, because as a former assistant federal defender, I have relied heavily on them throughout my representation of Joe. And they are just an indispensable resource, so I have to give them a plug and say, go to their conferences. Every Tuesday, they have Tuesday group. It's a brown bag lunch. You can submit a memo and discuss your federal cases. They are doing kind of roundtable discussions, I think, every Thursday about kind of specific topics in federal practice. And so much of what I'm going to tell you about my representation of Joe has been my work being handheld by Nicole and Millie and Jeff Ertl and Matt Dodge. And so, in fact, I have oral argument that I will be handling set in the 10th Circuit September 29th. So I don't know what's going to happen. I'm the one doing it. I also handled his resentencing after we won our first appeal that I did not write. I think that Joe, and I'm going to talk a little bit about the facts, and I think the complications of where we are procedurally, because that could be relevant as you move forward in post-conviction work. But one thing about Joe that I think does make him very similar to your white-collar clients is that he has absolutely no criminal history. Okay, there's a lot of misconceptions about Joe. He's a former police officer, and a lot of the people that were working as undercover informants, confidential sources that testified as witnesses in his trial, many of whom have since recanted, do have criminal history and did receive benefits for their cooperation. So Joe is that client that is currently serving 21 years, and I'll break it down a bit because I think there's some misunderstandings as to what he's serving and for what. But he is the client that is sitting there in prison, in federal prison, and relying heavily on his post-conviction lawyers to get him out. And I think when we're dealing with clients that have minimal to no exposure to that type of suffering, you do have to, I think in the post-conviction context, context, as you do in every context in criminal defense, be very mindful of your client's needs. And I mean that emotionally, psychologically. Joe had cancer, he got a cancer diagnosis, he was in Butner for an extended period of time. But there's something that feels very different for our clients when they are post-conviction and when you are litigating an appeal or a habeas or a motion for a new trial. Because whatever they held on to in terms of that hope, as you were gearing up for a jury, they don't have that. And with Joe especially, he's very sensitive, and he has no exposure to the prison system. This is it. So the other nuance, and Tiffany perhaps will speak to this as well, as a board member of the Georgia Innocence Project, I am very familiar with her heroic work in Devonia Inman's case, and what often happens when you are so far removed from some of the initial proceedings is that you have a lot of different attorneys, right? There's a lot of cooks in the kitchen, and another big issue with Joe is that even though I've come in and done the lion's share since the first appeal was granted and remanded for resentencing, you are dealing again not just with the emotional and psychological issues your client may have at this point, but you're also dealing with a lot of attorneys that have maybe stepped away for whatever reason. And I think that these are aspects of post-conviction litigation that we don't think about as much as perhaps we should, right? You are in a different procedural posture, and that should affect some of your relationships. And so there has been some infighting. I am not a part of it. I'm neutral. I'm friendly to all of the former lawyers, but that is something that I think you have to prepare yourself for, have boundaries, and I think just you don't want a lot of, you want everyone to have a united front as much as you can. But in my situation, for example, I wrote Joe's second appeal. And by way of some factual background, I think a lot of people think that Joe is serving a long sentence for animal abuse, and that's not true. He's serving right now, I think, 21 years, the bulk of which is basically the stat max on the murder for hire statute. 10 years, followed by 10 years consecutive for one plot to kill one Carol Baskin. So he was represented by the federal defenders at trial in the Western District of Oklahoma. And then he had another lawyer take on the direct appeal. It was a full-fledged jury trial, and the attorney that handled the first direct appeal filed a lot of continuances, which I think was frustrating to the client, and then brought up 2 issues, period. Which I think was surprising to any of us who do this work, especially after a jury trial. There certainly were a lot of transcripts, and then there was a lot of sentencing issues, and then before, the federal defenders had done a lot of pretrial litigation. And so I think those of us retrospectively were surprised to see only 2 issues. One of them was whether Carol was a victim, such that she couldn't be in the courtroom, was she a victim so that she could be in the courtroom, or should she have been sequestered? So really only one issue as to his conviction and sentence and trial. And so that was a grouping issue. We did prevail on the grouping issue, which sent the case back to the district court for resentencing. And that's when I came in. I think the team needed somebody to handle a federal sentencing. And what happened, and I think that this is something that might come into play if you're trying white-collar cases and then engaged in extensive post-conviction litigation, is that we had been planning on filing a very powerful motion for a new trial. So it would be under Rule 33B1, newly discovered evidence. And you have a clock. You have 3 years to do so. But timing-wise, the way it worked out for us was that that due date was right around the same time where after our resentencing, I thought it would be in our best interest and in Joe's best interest to appeal the new sentence. So now we have a client who has a pending motion for a new trial in the district court, but I also filed my notice of appeal to bring us back to the 10th Circuit. And so again, I think with client management, obviously the district court does not have jurisdiction. It's now with the 10th. But the client is thinking, wow, you just filed this incredible document that's hundreds of pages and has this groundbreaking evidence of my innocence, and the government's not going to do anything, the court is not even going to have a hearing on this? No. The interplay, obviously, of Rule 4, the appellate rule, versus Rule 33, motion for new trial, makes clear that we're going to deal with this sentencing appeal first rather than the motion for new trial. And so I think on one level it's been disappointing for the client, but I do think that our sentencing issue on the second appeal is decent. And if we prevail, another thing to think about is sometimes having concurrent litigation in both the district court and in the circuit court could result in potentially benefit. So for example, and this is again courtesy of Nicole Kaplan, it might be the kind of thing where when I argue in front of the 10th Circuit, I ask if the court would reassign the case to a different district judge. And now we have a different district judge entertaining our motion for new trial. And in this case, that would be very good for us because, well, for a number of reasons. But that's something that you can think about when you're dealing with a pending appeal, but then also thinking of coming back to the district court. The other thing is, so Joe, his first appeal was a grouping issue. And this, basically the argument was that this one plot to kill, one Carol Baskin, should have been grouped, right? They shouldn't have had additional points assessed under the US sentencing guidelines given the grouping rules. And the 10th Circuit agreed, and so then it came back. And the language in the mandate said, we remand this case for proceedings consistent with this opinion. So, always, I know you guys know this, but that to me was kind of a green light to take this as far as we could take it. And so at that point, even though I wasn't the first appellate lawyer, it was, in my opinion, an opportunity to maybe clear up or correct some errors that had occurred during his first appeal. So if you are in a circuit or a district where the mandate rule says, we prefer a general mandate. We prefer a general mandate unless we specifically tell you we remand for resentencing to correct this grouping error, I think take it and run. Because my experience with Joe was that despite the fact that I even filed a motion talking about multiplicity and the consecutive sentences and how the 10th Circuit's opinion about how counts 1 and 2 should be grouped, should kind of carry over into this constitutional argument, the court did not limit my ability to make those arguments. And so then when I wrote my appeal, even though we were just remanded for a grouping issue, my appeal has to do with multiplicity and that one plot to kill one Carol Baskin should run concurrently, not consecutively. And I think the fact that the court has even asked for oral argument is something that gives me a little bit of a reason to be optimistic. But then, of course, when you go back for your oral argument, in this posture, so much of what you have to consider is not the merits, right? I know the government's going to come in and they're going to say she shouldn't even be able to argue any of this, and they're only going to make an argument as to the merits at the very end. So much of what you're preparing for when you're in this posture is procedurally, what am I even allowed to argue? What has been foreclosed by virtue of the fact that another lawyer that wasn't me failed to raise this in the first appeal. So that's where we are with Joe. Presumably, once the 10th Circuit makes a decision, then the district court will turn to our motion for new trial based on newly discovered evidence. Obviously, that's a very high and difficult burden, but the fight continues. And I think at the end of the day, my experience is that client management is very important and very different than it is during direct trial representation. And oftentimes, you're not just singularly focused on one aspect post-conviction. You have a lot of moving parts, and it's key to know exactly how each piece of litigation affects the other. So that's pretty much it when it comes to advocacy.
I looked for my matching shirt. It must be at the dry cleaner. Incredible photo. But thank you for sharing all of that with us, Molly. So I'm wondering, the oral argument is set in October on the second appeal.
September 29th.
September 29th. I'll be tuning in. Hopefully, there's a way to listen to the oral argument. I'll try to do that. Tiffany, I know that you've had experience in procedurally challenging cases as well, and had some thoughts to tack on, and also maybe segue into your case.
Sure. Well, thank you, Brett, and thank you for the generous introduction. It is an honor to be here with this panel of women, and it's an honor to be at this conference. I do not have TikTok or Instagram, but I did mention on my LinkedIn not too long ago that this is really a full circle moment for me. I was at this program 5 years ago and saw Rob Carey speak about his work in the Turner case before the Supreme Court, which is Brady violations relating to some gentlemen and a group of young African American men in Washington, D.C., who were convicted of a violent crime based largely on false confessions and some withheld evidence. Out of that came some bad precedent under Brady, but nevertheless, I left the conference with a charge to go back to Troutman and demand more resources for Devonia's case. And I owe that credit to the firm that they stepped up and did that. And I see Bria in the audience from Polsinelli was one of the associates that I got to manage, so thanks is due to her as well, and some other people that you all know, like David Chaikin, was with us at the time and jumped in head first and gave us a prosecutor's perspective, which was valuable as we pulled together our petition. But I have several things. It's funny how different our clients are, but how many common threads run through these post-conviction cases. And for those of you who don't know, so Devonia Inman was my client. He was 19 years old at the time he was arrested in Adel, Georgia, which is very south, about 30 minutes north of Valdosta. This was 1998. He was arrested on a probation violation a few days after this murder occurred and never saw the light of day until this past December. The murder was of Donna Brown, a middle-aged Caucasian woman who was the night manager at the local Taco Bell. She was robbed at gunpoint and shot at close range, and her vehicle was stolen. His case is exemplary, not probably for broad applicable purposes, but it was a lesson in legal creativity and perseverance, which in this post-conviction context, whether it's appeal or when you're juggling multiple motions, is critically important. But it was exemplary from a factual perspective. Any crazy thing that you can think of from your favorite law movie or your crime novel all happened in this case. As I strongly encourage you, all the folks who've told this story better than I have, Bill Rankin of AJC, The Intercept, and Hillary Burton Morgan of One Tree Hill fame for Sundance TV, all have told the story better than I can in this short period of time. But just by way of example, there were pretrial recantations in Devonia's case. A juror was excused midstream for failing to disclose that he had intimate relations with 2 witnesses. The judge was reported to have slept regularly throughout the trial, and this was a death penalty case, even though my client did not receive a death penalty. The judge said really fun things on the record, like, oh, I guess we have just all threw the evidence book out the window yesterday, with no effort to correct or improve what was happening in the courtroom. What else? Took my client 4 years to get a transcript from his trial in order to pursue his appeal as kind of gotta have the transcript. GBI and Adel Police Department failed to collect a ski mask that was in the victim's car that was recovered, a potentially important piece of evidence. It was returned to the GBI by the victim's family. Said ski mask ultimately was tested for DNA, which unsurprisingly returned to the alternate suspect that everyone thought committed this crime, although many years later. The district attorney in the case was federally indicted for conduct in office. He pled guilty and was disbarred. The assistant district attorney who prosecuted the case was federally indicted. He eventually took his case to a bench trial and won. But all of this happened, and when you're sitting here hearing it, you're like, okay, well, it seems pretty likely that something was unfair and how this proceeded. And yet it took 23 years for us to get Devonia a fair shake. The other kind of extraordinary thing about Devonia's case, and this touches on what Molly said about procedural complexity, Devonia, despite all these crazy things that happened, had an extraordinary amount of legal process, which is not common, particularly for state offenders who are represented by a public defender's office or a contract attorney working for a public defender's office to have a lawyer at every phase. But Devonia filed a motion for a new trial, timely. It was amended twice by successor counsel. Direct appeal, that was taken all the way to the Supreme Court of the United States, of course denied. He filed a federal habeas petition. He was able to secure a certificate of appealability of the 11th Circuit, took it to the 11th Circuit, that was denied. Filed an extraordinary motion for new trial based on the DNA and appealed that to the Georgia Supreme Court. And all of this happened with lawyers. And yet again, we're talking about Trump got involved 15 years after his conviction, and it took us another 7 to really get before a judge and have the merits heard on his claims. And there's this tension, particularly we came in when all of this process had been exhausted. I had just come off of federal clerkship, and someone thought I knew what habeas was and therefore should take the case. And it's, okay, where do we go? What do we do? Where do we even start? And there's a huge tension, as Molly suggested, between the client. The client has maintained his innocence since the beginning, wants to move forward, thinks they have great claims, wants their day in court. But on the other hand, you have to decide how much time and effort do we put into this, right? So do we kind of stake out what we think are the really winnable claims and do a very nice, clean petition on what we think is winnable, or do we throw the kitchen sink at it? And the kitchen sink usually means you're doing reinvestigation of a pretty significant magnitude, as we did for Devonia's case. I think, and I only know these statistics because we had to file an affidavit, but I think in the end, after I marched back to Tom Riley's office and demanded more people, we had over 6 or 7 years, 60 timekeepers put more than 4,000 hours into this case. And your average person obviously cannot afford that. And even the average lawyer does not have those resources and time. So kind of, how do you balance between those tensions of, do I make a shorter petition to go with my best claims? Do I fully reinvestigate? Do I pursue parallel tracks? For instance, in Devonia's case, his extraordinary motion for new trial on the DNA testing was pending at the same time his federal habeas was pending. I don't think that was strategic at the time, unfortunately, and I think there was some detriment that the attorneys handling those were communicating, but perhaps the federal district court was not aware, for instance, of the DNA test results that reflected someone else. The ski mask belonged to someone else and the perpetrator was someone else. But kind of going back to what I think about how do you answer that question, how do you strike that balance? And I think there's really four buckets. Transcripts, we talked about, have to get the transcripts and read the transcripts. Records is the next big piece, and you'll want to beat your head against the wall. I know Bria made many trips to AL, Georgia. We would file requests for records, and then we would file a request for records, and then we'd file the same request for records, and then 6 months later, we'd file the same request for records, and we did this infinite number of times, and almost every time we would get something different back. And this includes from the GBI, so this is not just a Adel, South Georgia, 1998 case issue. But kind of along with that records piece is the power of Brady claims, and we can certainly talk about that a little bit more. But I'm probably cynical. I know this is a defense panel, so you probably all feel this way. But I think because of the proliferation of discovery and data, and general disagreements probably on both sides of what is Brady material, that there's likely Brady material lurking in new cases and really old cases. You know, it's kind of, in new cases, it's because of the proliferation of data. In old cases, it's because of generally poor record keeping and nothing is in electronic fashion. So I think that's a really ripe and powerful area for claims. And the other bucket, which Molly mentioned, was prior counsel. Interestingly, in our case, Devonia's lead counsel passed away during all his post-conviction efforts. His second chair trial counsel, who, as you would imagine, did a lot of the grunt work. It was her first death penalty case when she tried the case. It was also her last. She fully believed in our client's innocence and was 0% willing to help. We had to get a court order to get our client's file from her. So, I mean, in that sense, it was very adversarial, and we had to look at every letter she wrote on the page to determine what she did and what she knew. But I think Molly's advice is right, is that even when it's people you know, you have to kind of start fresh and evaluate what was done and what someone may have missed, because we do make those mistakes. And kind of the last piece of striking that balance is kind of the very obvious, your statute of limitations. And when you have the opportunity to choose between federal and state, there's some very interesting dynamics there. We had to do that analysis for the Inman case. Again, I keep looking at Bria because she had to do a lot of that research. Thank goodness. But we, again, that was one of the first things. We spent a year, honestly, researching. Like, we don't even know where to file this darn thing because the client has been before the court so many times. And, our options were the 11th Circuit, or just, a second or successive habeas petition, which the standard for that is laughable. Yes, thank you, Nicole. Nice and tired laughing. You have to get permission from the 11th Circuit Court of Appeals to even file it. The standard's clear and convincing evidence, and you have a 1-year window. That was not very attractive to us, and I think we had already blown like a statute on one of our claims. The state, I'm generally terrified of state court. I generally practice in federal court. I view it as kind of the wild, wild west. We have not had the best experience with the Cook County District Attorney's Office. Our client was sitting in Valdosta State Prison at the time, which, as you can imagine, perhaps not the kindest venue to clients convicted of murder. But we learned through this process, and I pitched to you all that there are some great benefits to habeas in the state court. I think one of those is discovery, and I think Nicole can touch on this one too. But under Georgia law, by statute, you're entitled to discovery in a habeas proceeding. And I understand from Nicole that that is no longer the case, essentially, in federal habeas. Also, in state court, you have a 4-year statute. And then it is a quasi-civil proceeding, so there are opportunities to really get creative, and we did so in Devonia's case, not in a precedent-setting way, unfortunately, but we pursued an adverse inference with the judge by seeking to depose the alternate suspect. He refused to come out of his cell, which they got on video, which was entertaining. But the judge then used that as part of the broader view of the evidence in deciding whether our client had established his claims. And then lastly, the other avenue that we touched on, or that we looked at, was Rule 60B, to kind of reopen our client's federal habeas. This was Dave Chapin's great idea. Again, ultimately did not go that route, but Nicole, I think, do you want to touch on that?
Sure, and I will say, to echo what both Molly and Tiffany have said, it's when you're in post-conviction, it's very complicated, and you're already playing three-dimensional chess. One of the most difficult things I have found over the course of my career, even if it's someone else in my own office, it's always hard to pick up somebody else's case, right, as opposed to litigating it from day one. And because you're having to live with the decisions that somebody else has made, right, that you may or may not agree with. But it's worthwhile to litigate, so, and I'll try to 60 at the end, but it's, you do have to be creative. You may be on appeal, and maybe the objections were not made at sentencing that you would have made to the guidelines enhancements, or maybe evidence came in at trial that you would have objected to, and you think to yourself, I'm going to be on plain error. There's no point in raising this issue. And I think you've really got to examine that closely, because to me, it is worth it to raise issues for a few reasons. One, maybe you can meet the plain error standard and actually win on direct appeal. But two, if you have a strong issue and the prior lawyer made a mistake, you're hoping to draw an opinion that says, but for it being a plain error standard, we would have gotten relief, and set your client up for a successful 2255. So you have to be thinking about all aspects of the litigation. I also don't do state court. I don't like state court. It's the Wild West. It's kind of crazy. But there are a lot of benefits to being in state court on habeas as opposed to federal court. The Supreme Court this year, for a state conviction on 2254, the Supreme Court essentially gutted evidentiary development in federal court in Shindy Ramirez. They said, yes, you may have had ineffective assistance of counsel at your trial or your appeal. Yes, you may have had ineffective assistance of counsel on your first go-around in habeas under Martinez v. Bryant, but you don't get to develop evidence about that. You should have done it earlier. Now, how you can do that earlier with ineffective assistance of counsel, I don't know. The 11th Circuit and the Supreme Court to an extent, but certainly the 11th Circuit, who I know and love very well, they're obsessed with finality, and I'm not interested in finality. I don't care about finality. I'm interested in justice and the right outcome. So you have to find a way to get around that. Rule 60B, there was a case that we were really afraid of in the Supreme Court this term, but I think it gives us an opportunity to be creative, because it says a judge's legal error is a mistake that is cognizable under 60B1 with a 1-year statute of limitations to file that claim. So we have a lot of clients who were in post-Johnson or post-Davis or DeMaia litigation saying their prior convictions shouldn't have counted to enhance their sentence, or a variety of cases that were being filed in habeas, and we were losing in district court because the 11th Circuit precedent was bad. But these issues were being litigated up to the Supreme Court. So we could go to the 11th Circuit and lose, but if the case is in the Supreme Court, a case that's going to decide your issue, or there's some other dispositive ruling that's going to come down that could help you, I think it's helpful to think about when is that ruling going to come down in the next year, such that I can have a shot at filing a 60B to get back in front of the district court and avoid the second or successive problem, and avoid the, dare I say, hostility of the 11th Circuit to our client's claims. And so there's a lot to think through in terms of what is the right vehicle, what is the right jurisdiction, what is the right timing, and all of these clocks are running. As Molly said, you're trying to manage your client's expectations, but because it is so easy for the 11th Circuit to find waiver or procedural default, this is my personal thing because it makes me crazy. I think there's been a couple cases this year where the government can do whatever they want and not raise claims and has never abandoned it, and the 11th Circuit's going to fix it for them. But we don't get that luxury. So you have to manage your client's expectations because you have to take the time to investigate, make sure you really understand what all your claims are so you can then make a strategic decision about the best forum and the best time. And so if you have a client who has a state conviction, I think that state habeas, the rules are much more friendly, even if the venue where the judicial officer is not. So you can get a lot of development there, that even if you don't win there, it will hopefully build your opportunity to win later. If you don't do that factual development, in state habeas, you're going to be absolutely stumped when you get to federal court. And I will say, we see this all the time in our death penalty cases. You ask for the Open Records Act request, you do that, and you will continually get new information. And so it does, as frustrating as it is, it's worth it to do it over and over again. It's worth it to go down to the clerk's office and look at the file yourself. We've had a couple of cases with Brady claims and juror misconduct claims where when we sent someone to look at the file in the county courthouse, there were the notes that the jury sent the judge that were never disclosed to the trial lawyers. There were, when you go to the local police department and you look at their file instead of just doing the ORA request, there's the report about the other suspect or the DNA or the witness who lied or the person who got the payoff that was never disclosed. Because generally I think the prosecution isn't thinking about our cases the way we're thinking about them. And so what is obvious Brady and Giglio to us is not always obvious Brady and Giglio to them. And so you've got to do the work to find it yourself.
Yeah, and just to add, I don't know that I ever would have pictured myself up here advocating for the Georgia judicial system. But I will note, please take a look at that memo in our materials about some recent developments in Brady. We could do an entire panel on Brady. But there have been some shockingly good decisions out of the Georgia Supreme Court in the past 2 years relating to Brady. Both of them being about diligence, which gives you some relief on the procedural and the timing. You are not required to go do as Troutman did and have 60 timekeepers spend 4,000 hours to find a piece of Brady material. You are not required to send infinite open records requests to random case files that don't even relate to your client to find Brady material. You are not required to go interview jurors in the middle of ADL in the middle of summer to try to find exculpatory information. So that there are some really great precedents that have come out about Brady under Georgia law, which is frankly in pretty stark contrast to what's going on federally, notwithstanding the Due Process Protections Act and that lovely little preamble that we get in front of magistrate judges. And then Nicole mentioned procedural default. You all may have heard about kind of this miscarriage of justice exception. It's explicit in the statute under Georgia that this is, it has not been used very often, but the language is really powerful and it gives me hope for like Georgia habeas. Basically, the statute says, in all cases, habeas corpus relief shall be granted to avoid a miscarriage of justice. And there's a lot of play in that. That's powerful. And granted, there's some argument it's a really narrow procedural default issue, but that's a statement of the legislation made in the statute that we certainly used in our case as a backstop to an argument. These claims should be heard and they shall be heard under Georgia law.
Well, Devonia, an incredible effort, incredible result, still incredible justice. At the end, I want to talk about the compensation avenues and where you all have had success if we have time. I did want to mention in the materials that we've provided, there have been some courts that have been willing to kind of but enforce the burden on the governments to identify or provide in a way that can be effectively used at trial Brady materials. And so a motion that Charnel is familiar with is included in the materials, and there's an order from the magistrate judge in the Northern District of Georgia that effectively says in the 22nd century, where we've got millions and millions of pages of electronic data and people are entitled to their speedy trials, maybe you do have to identify in good faith where you believe there's Brady material if you're the government. And so we're pushing that in cases, and I'd encourage you to take a look. Okay, so next slide. All right, this is my reminder. So it's a timely mention from our president, our former president, about handling classified information, but it's my reminder that we tried lots of things in terms of compassionate release, clemency part. We tried everything with a former client and had limited success, but we have panelists who have had great success pursuing these avenues. And so maybe that tweet gets more play in litigation or media cycles, but I thought it was interesting enough and a reminder to get us on track to talk about compassionate release and clemency and pardon work. So as Nicole can probably tell us real quickly, the status of compassionate release is not great here in the 11th Circuit, but we'll start there.
It's on life support. The 11th Circuit is an outlier on compassionate release, but it is not dead. So, as I'm sure you all know, we had to rely on the Director of the Bureau of Prisons to file compassionate release motions until the First Step Act passed. And there are plenty of Inspector General reports that you can go read if you're so inclined about what a terrible job they did in identifying and filing those motions. And people were dying in prison that didn't need to be there. So, under the First Step Act, a client can file themselves. They have to exhaust their administrative remedies, ask, wait 30 days, and then they can file. What are extraordinary and compelling reasons for compassionate release is the $64,000 question. We had great success in the early days of COVID in getting release for clients who had underlying conditions like diabetes, obesity, that were known risk factors for elevated serious illness and death from COVID. We had many clients released. And then the 11th Circuit shut it down in the Bryant case and said that even though the statute just says extraordinary and compelling reasons, the guideline refers to what the Bureau of Prisons can do. We are bound by what the guidelines commentary defines as extraordinary and compelling reasons. I believe the 11th Circuit is still the only circuit to hold that, and that's being litigated up into the Supreme Court, so we'll see. But you can still get compassionate release for clients, and we are getting compassionate release for clients who are otherwise meeting that criteria. Terminally ill, have lost the other parent, and they are the sole caregiver for the child. The criteria are set forth in the commentary to 1B1.13. I'm very hopeful that now that we finally have a quorum on the Sentencing Commission, that this is going to be one of the first items they take up to amend 1B1.13 to broaden the basis that our clients can seek relief. I'm also holding out hope that the Supreme Court will take a cert petition and say that the 11th Circuit in Bryant is wrong. It is a textualist argument, that's kind of groovy, that's their thing. So I'm cautiously optimistic, unless Neil Gorsuch breaks my heart, which he doesn't want to do, but I'm going to hold out hope that they're going to give us relief there. But compassionate release is not dead, and if you have a client you think is eligible, we filed a lot of these, we have a lot of statistics, so we're happy to help and support you in that quest in any way that you want. So feel free to email me about that, and I'll talk to you off about it.
And Emily, you've had success filing these motions.
Yes.
Tell us about how you've had success and what we should be doing as practitioners.
So primarily during COVID is when I had most of my success, and AG Barr issued this memorandum directing the BOP to consider other factors and who should be released early. It opened the door for a lot of people to submit their own petitions to the BOP. 31,000 people requested early release. I think 36 got it with the BOP. So the remainder of those people, before Bryant in our circuit, could go to the court and ask the court for relief. And again, with the federal defender program, I did a lot of these that I could not have done without my judge. I was emailing him 3 or 4 times a day. He was responding to me 3 or 4 times a day, calling me at 9 p.m., sending me charts on every compassionate release in every circuit in the country. It was just really, really great resource. But yeah, so what I did, I think that, I'm not sure a lot of people were doing is I took the opportunity to look for other issues that maybe aren't really compassionate release issues, but I think are relevant if the judge is exercising discretion. For example, this is more on the clemency side, but if there was an 851 file that was filed today, I'd make sure to educate the judge on that, things like that, and reasons why the sentence might be lower despite, or in addition to reasons they should qualify for compassionate release. I also would present 3553 that wasn't presented in sentencing, and I just made sure, whether or not the judge was going to consider it, to put more than I needed to in there, other reasons why, if they're exercising discretion, they should release these people early. And I will say, our judges granted a lot more of these than I expected them to. I think I filed in our district 7, and 4 of them were granted. So the judges, and by some tough judges too. So they actually did a really good job, a lot better than some more sort of aggressive districts. But a lot of that I think is meant and I'm not being sarcastic on that. But yeah, so I think that any opportunity you have, hopefully, like Nicole says, we'll have another judicial audience for these, I'm sure. I think we will. I think any opportunity you get in any sort of judicial post-conviction proceeding, like Nicole touched on, put everything in there. Maybe they won't consider it, maybe they will, maybe it sets them up for something in the future if the commission changes something else and you have something on the record that it might apply to your client. I don't think it hurts. Again, know your audience. Certainly wouldn't go too far with certain judges, but for the most part, anything that wasn't presented initially, I'll put in there. Considered.
Well, I was going to take it a step further. Our habeas petition probably was close to 100 pages, and we certainly put all kinds of things in there that we knew, transcript-based errors that should have been litigated, 15 years ago. But as we all know, the story is important. And if there's any inkling that you have a judge who is sympathetic or has a little bit of discretion, and that full picture about the injustice is hugely important. And you said the same thing with appeal. So
You have to tell the story to make them want to grant relief. And it is relevant. The Supreme Court has said that when you're coming back, under Pepper, all of your client's conduct from the time of sentencing to when you're redoing this is relevant. And so you have the buck to get it in there.
So Emily, did you get any of those 4 that were successful? Were any of those under the catch-all provision?
Yes. Well, not in this district. I did have one in the Southern District of Florida that was.
Okay, and now we're effectively precluded here, but Nicole, your office is still filing some if you think they're good cases.
Yeah, so we are filing now for clients who can meet the criteria for illness or the over 65 and having served a certain percentage. We are keeping lists. Matt really is the master of data. He really helped us alter our practice. We are keeping lists of clients who we would file for if the criteria, if Bryant gets reversed or the criteria changes. And that's the
Okay. And there is hope because the quorum that didn't exist previously now does, right?
it does.
We did a lot of finger crossing in our Zoom practice this morning.
Well, so, and then the final question I have, and maybe this is a question for the sentencing panel, and the panel will handle first step back in detail, but Bryant, I believe the status was a cert was denied, maybe because now there's a quorum, right? The sentencing commission has been, the panelists have been filled, but is there another case that you're aware of that raises the issue?
There are other cases in the pipeline from other districts. I believe in the 11th Circuit. Don't ask me the name of it. But yes, it is being litigated. And it is against a backdrop which I think is relevant for all of our clients who are going to sentencing. There was a hearing in front of John Ossoff's subcommittee about the conditions of the Atlantic Penitentiary, which are writ large. The throughout the BOP, the understaffing, the failure to provide programming, mental health, physical health treatment, all of these issues. And so we're continuing to push the compassionate release issue. I mean, I have a client who has been denied compassionate release. He's already blind in one eye. He's been waiting over a year and a half for cataract surgery in the other eye. They won't move him to a facility that will do it. They've lost their contract to do it where he is. And he's going to lose his vision in that eye because he can't get treatment. We've been denied compassionate release. I'm going to file again in another 3 months if he hasn't had surgery yet. I've filed with the warden, with the Inspector General, with Washington. He's working on an NTD-3 suit, but it's all, there's a lot that needs to be fixed. And this is also a tool to educate our judges about what's going on in prisons, so that then when you're doing a good old-fashioned vanilla sentencing, they have that background and knowledge about what it really means to send your client to prison.
And there's a lot of other aspects of the First Step Act that I think apply to our white-collar clients even for purposes of this white-collar convention, right? And we just wanted to blurb or plug, I think, that panel, because it's part of the toolkit. Go ahead.
Sure. So yes, I highly recommend going to that panel. I think our white-collar clients who have no criminal history are right to take advantage of the First Step Act, earn time credit, and get time off their sentence. Our clients are scored out into 4 categories: minimal, low, medium, and high. If the client scores as a minimum or low, they can both earn the credit and apply the credit, either to early halfway house time or to straight up early release to supervised release. We've heard good things because BOP is short-staffed and the programming is limited. As long as your client is on the wait list and not actually refusing, BOP is going to consider them as being in programming and earning that credit. What they need to be wary of is BOP has to do what's called a needs assessment, and that's going to involve several things, including meeting with the unit team, but also filling out probably several questionnaires on the tablets that are provided. And if they don't do the questionnaires and surveys and needs assessment paperwork that they're supposed to do, which may or may not be communicated to them clearly from their unit team, then they are going to be deemed as refusing programming and not mirroring that credit. So we need to be educating them to ask, what do you need me to do? What do you need me to complete to be deemed in programming so that I can get that credit? They score our clients on both the regular, minimum, low, medium, and high score. They also do a separate violence score. So, and whichever one is worse is the one your client gets assigned to. So, our typical fraud or white-collar client who doesn't have record is going to be minimal or low on both of those, hopefully. The problem with those scores is that they're almost all static factors that your client cannot change except getting older. None of them change. So if they are a medium or a high, it's going to be very difficult for them to work their way down to low or minimal. If you're medium or high, you can earn the First Step credit, but you can't apply it. There's a lot of litigation, I think, that's going to be done over the course of the next few years. Implementation of this was delayed because of COVID, so we're only just now beginning to see how it shakes out, and so I'm hopeful that those things will change over time. But certainly for this client base, they should be getting the benefits of that program.
And even for the non-white collar client base, I have clients who are going to be high designation, and I'm still encouraging them to take advantage of these programs so that if it does change, they will or should be eligible for the credits. Because I have one client that's like, I'm not even going to try, I'm not going to do this, and they just not do it anyway, because that can change and increase that benefit.
So as maybe to wrap up with the final part of the toolkit we were going to discuss today, let's move on to clemency and pardon work. And there's a lot of that going on. And Emily, I know that you were part of former President Obama's Clemency Project initiative, and I'm hoping you could kind of tell us about your experience through that program and how it might translate to work we can do, and also, it's been suggested that President Biden may have an initiative, pending as well. So, what are your thoughts on that?
So that was a rumor I heard during the election. We all heard it. It's been a while, so I'm still hopeful. But as of now, there is no similar program. If there is, I would hope it would be more expansive than the original, because the original was very successful. Almost no citizen to people that qualified for these rejections, or very little. I think it's like 5% or something. So I'm hoping that they would sort of open the pool of people eligible to a broader audience. The program I worked for was not necessarily super white collar focused, because the main criteria, the one criteria you had to meet was that your sentence would be substantially lower today. So things like the Second Chance Act for or enhanced violence that became discretionary. Those are the things you're first looking for when you get assigned a case. So the way the project worked was volunteer attorneys were assigned cases, and there were two different screening processes. It's not like you're writing to a judge. You're not trying to be persuasive. You're trying to be honest, because cases are it's not going to go anywhere. They want to get it out, they want to close it, get someone else on it, and might actually have some success. So the first screening process is just, there were these enhancements that would apply, this or that, and if it meets that sort of level, it goes to the second screening process, where I would write what would essentially be the petition I would submit to the Office of the Pardon Attorney. But what they wanted to do, for obvious reasons, is go through it and make sure it had a good likelihood of success, because the program wanted to have a high success rate, which makes sense when you fund any things like that. So, generally speaking, most of the petitions that went through the program in the early days, most of those people did get a commutation of their sentence. There were so many that I don't think they were all reviewed. They said they were. I'm sure it's impossible. The other thing about the Office of the Pardon Attorney is they're under no obligation to give you a reason for a denial. So in terms of doing it again, I'm going, it works, so it doesn't work, you really don't have an idea. So that's kind of frustrating. And I would reach out and try to ask it. And they are not limited to that, I get that. The good thing about the clemency criteria is, aside from that initial criteria that the sentence can be very different, pretty much every white collar defendant meets the other factors. Things like nonviolent offenses, low criminal history, good prison conduct, low pattern score, which I don't know if you guys know what a pattern score is, but it's some bogus algorithm that tells you whether or not someone's been recidivating, and things like that. So those things are all, generally speaking, things your white collar clients meet. So if there is a new program, and it is more expansive, and I do think if there is a program, it will be more expansive. I think the EOP is understaffed, and if people across party lines realize that prisons are overpopulated, and prison population reduction is really important in times like these, which just seem to be getting crazier. So I do think if there is a new program developed, it would be more expansive. It would include more white collar defendants.
You're going to get involved in it.
Of course.
Thank you for your work.